This video is provided for educational and informational purposes only and does not constitute legal, real estate, or professional advice. I am not a licensed real estate attorney, realtor, broker, or legal professional in the United States. The information shared in this video is based on personal research and publicly available sources. Nothing in this video, or in any related content, creates an attorney-client relationship or any other professional-client relationship between you and me. Real estate laws, transaction procedures, and professional responsibilities vary by state and jurisdiction. You should always consult with a licensed real estate attorney or licensed realtor in your state before making any property, legal, or financial decisions. I make no guarantees regarding the accuracy, completeness, or applicability of the information provided. Any actions you take based on this content are strictly at your own risk. Imagine this for a second. You've just closed on your dream home. The boxes are half unpacked. The smell of fresh paint is in the air, and you're picturing your future in this perfect space. Then, a week later, a certified letter arrives. It's a legal notice from the city. It turns out that the beautiful new deck you were planning, the very one you told your realtor was a must-have project, violates a zoning ordinance. Or maybe your neighbor shows up with a survey, informing you that your driveway actually encroaches on their property line by 3 feet, and they have a legal easement giving them access right through your backyard. You call your realtor, the person who held your hand through the whole process, and their response is a pit in your stomach. Wow, that's tough. I'm so sorry to hear that, but that's a legal issue. You'll have to get a lawyer. That single moment is where a 5, 6, or even 7-figure mistake is born. And it all stems from one of the most common and dangerous misunderstandings in the entire U.S. property market. Not knowing the profound difference between the person who helps you find the house and the person who ensures you can actually keep it problem-free. This isn't just about semantics. It's about the fundamental difference between sales and legal protection. It's the difference between a smooth closing and a financial nightmare that can follow you for decades. Most people think their real estate agent has them completely covered. They're your guide, your negotiator, your confidant. And a great realtor is absolutely invaluable, but their job has a very specific boundary. A line in the sand that once crossed leaves you completely exposed. On the other side of that line is the real estate attorney, the one person whose sole, undivided, legal and ethical obligation, their fiduciary duty, is to protect your legal and financial interests and nothing else. They don't care about the sale. They don't get a commission when the deal closes. Their only job is to protect you. So in this video, we are going to pull back the curtain on the 2 most critical players in any property deal. We're not just going to list a few bullet points. We are going to arm you with a deep, practical understanding that will transform you from a hopeful homebuyer into a savvy, protected owner. You will learn the precise roles and, more importantly, the limitations of a realtor. You'll discover the specific red flags in a transaction that should scream, "I need an attorney now." And you'll get the exact questions to ask both of these professionals to ensure your team is built for total protection, not just a quick closing. This is the conversation that could save you more money, stress, and heartache than any price negotiation ever will. Let's start by detonating the single biggest myth in real estate: the idea that your realtor is a jack of all trades. We see them on TV, handling every little detail, solving every problem, and it creates this illusion that they are your all-in-one guide. But here's the unvarnished truth. A real estate agent is a licensed sales professional. Their expertise is in marketing, pricing, negotiation, and navigating the local market. They are masters of the deal. They find the buyers, they show the homes, they write the offers, and they are essential to bringing 2 parties together. They operate on a commission basis, which means they are highly motivated to get the deal across the finish line. And that motivation is great. It's what you want, but it also defines the scope of their role. They are legally and ethically barred from giving legal advice. If they try to interpret complex contract clauses, advise you on different ways to hold title, or explain the legal ramifications of a deed restriction, they are not only stepping outside their area of expertise, they are breaking the law in most states. It's called the unauthorized practice of law, and the penalties are severe for a reason. Because a simple misinterpretation of a single sentence in a 100-page contract can have catastrophic consequences. This is where the attorney enters the picture. Think of it this way: your realtor is your offensive coordinator. Their job is to strategize, find openings, and score the touchdown, get you the house at the right price. The real estate attorney, on the other hand, is your defensive coordinator and the team doctor. Their job isn't to score points. Their job is to read the other team's strategy, to protect you from blindside hits, to check for hidden injuries before they become critical, and to ensure that when you win, the victory is legitimate and can't be taken away from you later on a technicality. The attorney's entire focus is on risk mitigation. They are trained to be paranoid on your behalf. While you're falling in love with the granite countertops and the open-concept kitchen, your attorney is digging through the title report, looking for skeletons. They're searching for old liens from contractors who were never paid, undisclosed easements, boundary disputes, or breaks in the chain of ownership that could cloud your title and threaten your very ownership of the property. They review the mortgage commitment, the survey, the zoning reports, and the closing documents with a single question in mind. How could this possibly go wrong for my client? A realtor fills in the blanks on a standard, state-approved contract. An attorney reads that standard contract and tells you what those pre-printed words actually mean for you, your money, and your future. They can draft custom clauses called riders or addendums to protect you from specific risks. Want to make sure the seller is responsible for that leaky roof they promised to fix? An attorney can write a clause so ironclad that the seller has no wiggle room. Worried about getting your deposit back if your financing falls through at the last minute? An attorney builds that escape hatch directly into the legal language of the contract. A realtor can't do that. They can use the standard forms, but they cannot create new legal language. That is the practice of law. Now you might be thinking, okay, I get it, but isn't this overkill? My state doesn't even require an attorney for closing. And that is a critical point. The United States is divided. Some states, often called attorney states like New York, Massachusetts, and Georgia, mandate that a lawyer be involved in real estate closings. In these states, the question is already answered for you. But in the majority of states, known as escrow states or title states like California, Texas, and Arizona, attorneys are not required. A title company or escrow agent handles the closing. And this is where the danger lies. In these states, buyers and sellers often assume that because an attorney isn't required, one isn't needed. They see it as an extra expense, an unnecessary complication. The title company, they think, will protect them. But here's the crucial fact that gets missed. The title company agent is a neutral third party. Their job is to follow the instructions of the contract and ensure the closing happens according to those terms. They do not represent you. They cannot give you legal advice. If they spot a potential problem in the contract, they can flag it, but they can't advise you on how to solve it. They represent the transaction itself, not your personal interests within it. Relying on a title agent for legal protection is like asking the referee in a football game to also be your coach. They can enforce the rules, but they can't tell you how to win the game or protect you from a bad play. So the real question isn't whether your state requires an attorney. The real question is, how much risk are you willing to take on in the largest financial transaction of your life? Are you comfortable signing a legally binding contract worth hundreds of thousands, or even millions of dollars without having a legal expert, who is 100% on your side, review it first? For most people, when you frame it that way, the answer becomes crystal clear. The few hundred or couple $1,000s you might spend on an attorney is not a cost, it's an insurance policy. It's the cheapest, most effective insurance you will ever buy against a future legal disaster. And let's be brutally honest for a second. When you think about a property deal, what's the single biggest point of failure? It's not the paint color. It's not the school district. It's the paperwork. It's the dense, jargon-filled, legally binding contract that dictates the fate of hundreds of thousands, or even millions of your dollars. A realtor is your guide on the house hunting safari. They're the expert tracker, spotting the perfect property in the wild, helping you navigate the terrain of neighborhoods and market prices. They are masters of the art of the deal, the negotiation, the timing, the emotional current of buying and selling. A great realtor is worth their weight in gold for getting you to the closing table with a price you're happy with. But here's the critical distinction that most people miss until it's far too late. Your realtor is the pilot flying the plane. They are an expert at takeoff, navigation, and landing the deal. The real estate attorney, on the other hand, is the aircraft engineer who inspects the plane's structural integrity before you even get on board. The pilot can't tell you if there's a hairline fracture in the wing spar, but the engineer can. And that fracture is what can cause a catastrophe mid-flight. This isn't a knock on realtors. It's a clarification of their role, a role that is strictly defined and limited by law. In nearly every state, there's a concept called the unauthorized practice of law. This is a legal brick wall that a realtor cannot and should not ever cross. What does it mean? It means your realtor can help you fill in the blanks on a state-approved, boilerplate contract form. They can write in the price, the closing date, the names of the parties. But the second you need a custom clause written, or the moment you need a legal interpretation of what a specific paragraph truly means for you and your risk, they are legally forbidden from providing that advice. If they do, they are breaking the law. And more importantly, they are operating outside their area of expertise, which puts you, their client, in immense danger. Think about it this way. Imagine you go to your family doctor for a checkup. They can take your blood pressure, listen to your heart, and use their expertise to diagnose common ailments. But if they find a complex, suspicious-looking shadow on your X-ray, they don't say, "Well, I've seen a few of these, let me just open you up and take a look." No. They immediately refer you to a specialist, an oncologist, a surgeon, someone whose entire career is dedicated to that one specific high-stakes area. Your realtor is the family doctor of real estate. They are fantastic generalists. The attorney is the surgical specialist. You don't need the specialist for every sniffle, but when you're about to undergo a major life operation, and buying a house is arguably the biggest financial operation of your life, you want that specialist in the room. Let's talk about that standard contract. That phrase is one of the most dangerous in real estate. Don't worry, it's just the standard form. It sounds so reassuring, so safe. But standard does not mean safe for you. It simply means it's the most commonly used template. A standard off-the-rack suit might fit a lot of people reasonably well, but it won't fit you perfectly. It might be too tight in the shoulders, restricting your movement, or too loose in the waist, leaving you exposed. That contract is the same. It's designed to cover the most common, vanilla-flavored transaction. But your deal is not vanilla. No deal ever is. Does your dream home have a shared driveway with the neighbor? The standard contract has a standard clause for that, but is it the right one? Does it clearly define who pays for snow removal, or for repaving it in 10 years? Does it grant a permanent, legally recorded easement, or just an informal permission that the next owner of your neighbor's house could revoke, effectively landlocking your garage? A realtor can't answer that. They can only point to the standard clause. An attorney will read the existing easement, or draft a new one, that is ironclad and protects you and every future owner of your home. What if the seller did a huge, unpermitted basement renovation? The standard contract might have a checkbox saying the seller warrants there are no known unpermitted works. But what does that really mean? What happens if the city discovers it a year after you move in and orders you to tear it all out at a cost of $50,000? An attorney can build specific protections into the contract before you sign, clauses that hold money in escrow, that force the seller to remedy the permit issue before closing, that give you a clean exit from the deal with your deposit back if they can't. These are not standard clauses. They are custom-fit armor, forged for the specific risks of your transaction. This brings us to the most fundamental difference of all: the alignment of incentives. Your realtor has a fiduciary duty to you, which is a legal duty to act in your best interest. And the vast majority of realtors take this very seriously. But we have to acknowledge the reality of their compensation structure. A realtor typically only gets paid if and when the deal closes. Their commission is a percentage of the sale price. Therefore, their entire professional and financial incentive is geared towards one ultimate goal: closing the deal. If a problem arises, their instinct and their financial imperative is to find a way to solve it to keep the deal moving forward. They are professional deal closers. Now, consider the attorney. You pay them a flat fee or an hourly rate. They get paid the exact same amount whether you buy the house or not. Let me repeat that because it is the most important thing you will hear today. The attorney's payment is not contingent on the deal closing. Their singular, unadulterated, and undivided loyalty is to you and your legal protection. They have no financial incentive to push you into a bad deal. In fact, their entire professional reputation rests on their ability to spot risks and protect you from them. If an attorney reviews a contract, or a title report, or a zoning issue, and finds a problem that represents a significant risk to you, they will not try to smooth it over to save the deal. They will raise a giant red flag. They will tell you, "This is a major problem and here are your 3 options. We demand the seller fix it, we renegotiate the price to compensate for the risk, or you walk away from this house right now." They are your professional deal killer, if killing the deal is what's in your best interest. They are the person in the room whose only job is to protect you, even from your own emotional desire to buy the house. They are the objective, dispassionate voice of reason when you've already fallen in love with the granite countertops and the backyard. The realtor helps you find the dream, The attorney makes sure the dream isn't a carefully disguised nightmare. One is focused on the possibilities of the property, the other is focused on the liabilities of the transaction. You desperately need both. Relying only on a realtor to navigate the legal complexities of a purchase agreement is like asking your wedding planner to draft your prenuptial agreement. They might be amazing at their job, but it's the wrong job. They're playing in a different league with a different set of rules and a completely different set of consequences if they get it wrong. The consequences of a bad flower arrangement are disappointing. The consequences of a bad contract clause are financial ruin. So when you're looking at that purchase contract, that seemingly simple document your agent has put in front of you, you have to ask yourself a question. Is this just a formality to be filled out? Or is it the single most important financial document I will sign this decade? And if it is, who do I want reviewing it? The person whose income depends on me signing it, or the person whose sole professional purpose is to ensure that signing it doesn't destroy me? But the contract itself is only the beginning of the story, because sometimes the biggest threats aren't written in the clauses between you and the seller. They're ghosts from the past, hiding in the public record, waiting to claim your new home as their own. We're talking about the murky, treacherous world of the property's title, and the hidden liens and long-forgotten claims that can surface years after you've moved in, threatening your ownership entirely. And that is a place where only an attorney can truly protect you. Let's unpack that. Think of the title to a property not as a single piece of paper, but as the complete, unabridged biography of that piece of land, stretching back decades, sometimes even centuries. It's a story written in deeds, mortgages, wills, and court records. And just like any long, complicated story, it's filled with characters, plot twists, and sometimes a few skeletons in the closet. Your realtor's job is to help you fall in love with the house. Your real estate attorney's job is to read its entire, messy biography and make sure none of those skeletons will come back to haunt you. This process is called a title search, and it is the absolute cornerstone of an attorney's role in your purchase. This isn't a quick Google search. This is a deep, forensic investigation into the public record. The attorney, or a specialized title abstractor they work with, is essentially a property detective. They are hunting for anything that could compromise your claim to clear title. What does that mean? It means you and only you own the property free and clear of any other claims. So what are these property detectives looking for? First, they're hunting for liens. A lien is a legal claim against the property for an unpaid debt. The most common are mortgage liens from the seller's lender, which are normal and get paid off at closing. But the scary ones are the hidden ones. Imagine the seller had a new roof put on 2 years ago but never paid the roofer the final $10,000. That roofer can slap a mechanic's lien on the property. If that lien isn't found and settled before you close, guess what? That debt can become your problem. The roofer could legally force the sale of your new home to get his $10,000. Suddenly, you're on the hook for someone else's bill. There are also tax liens from the IRS or the state for unpaid income taxes, and judgment liens from someone who sued previous owner and won. These liens attach to the property like a barnacle, and they don't let go until they're paid. A realtor isn't trained to navigate the legal complexities of negotiating and releasing these liens. An attorney is. Next, the attorney is searching for easements. An easement is the right for someone else to use a part of your property for a specific purpose, even though you own it. You might have a 10-foot wide utility easement running along the back of your yard. This means the electric company has the legal right to drive their trucks onto your lawn, dig it up, and service their equipment whenever they want, and you can't stop them. It also means you can never build anything permanent on that strip of land. No swimming pool, no shed, no deck extension. What about a driveway easement you didn't know about? Giving your landlocked neighbor the permanent right to drive across your property to get to their own. A realtor might see an easement listed on a report, but an attorney reads the actual easement document. They analyze the specific language, tell you exactly what it means for your future plans, and identify if it's more burdensome than it appears on the surface. Then there's the hunt for encroachments. This is when a structure on a neighboring property illegally extends onto yours, or vice versa. The classic example is a fence built 3 feet over the property line. Or maybe the neighbor's new garage was built so it overhangs your land by a foot. Without a proper survey review by an attorney, you might not notice this for years. But when you go to sell, the new buyer's attorney will spot it, and suddenly your sale is in jeopardy until you can resolve a messy, expensive, and emotionally draining legal dispute with your neighbor. An attorney can spot these issues on the survey before you buy, and demand the seller fix it or compensate you for it. saving you a world of future conflict. But the deepest, most complex part of the title search is verifying the chain of title. This is the sequence of historical transfers of the property from owner to owner. The goal is to ensure that there are no weak links or breaks in that chain. A break in the chain can be catastrophic. What if, back in 1985, a husband sold the property but his wife's signature on the deed was forged? In the eyes of the law, that sale might be invalid, meaning the wife or her heirs could still have a legal claim to your house today. What if a property was passed down through a will that was improperly executed, and a long-lost heir who was cut out of the will suddenly appears with a valid legal claim? These sound like far-fetched movie plots, but they happen. The attorney scrutinizes every link in that chain. They're checking for fraudulent documents, clerical errors in legal descriptions, undisclosed heirs, and unresolved divorces from decades past. A realtor simply does not have the legal training to perform this level of forensic analysis. They rely on a title company to do the search, but here's the critical difference. A title company's primary job is to identify risk and then insure against it. An attorney's primary job is to identify risk and then eliminate it. That is a fundamentally different mission. When a problem or a cloud on title is found, a realtor's hands are legally tied. Giving advice on how to resolve a forged deed or a lien from a forgotten creditor would be the unauthorized practice of law, a serious offense. They can't do it. They have to tell you to consult an attorney. If you already have one on your team, you don't miss a beat. Your attorney gets to work. They might negotiate with the lien holder to accept a lower payoff. They might draft a legal agreement with the neighbor to resolve the fence encroachment. In severe cases, they might have to file a lawsuit called an action to quiet title to get a court order that extinguishes old, bogus claims and officially declares you the one true owner. This is the heavy legal lifting that protects your investment, and it's a world away from negotiating the price of the home. Now you might be thinking, what about title insurance? Doesn't that protect me? Yes, it does, and it's mandatory in most transactions. But it's crucial to understand what it is. Title insurance is a policy that protects you from financial loss due to title defects that were missed in the title search. It's a safety net. An attorney's job is to make sure you never have to use that safety net. Furthermore, a title insurance policy comes with a list of exceptions. These are specific, known issues that the policy will not cover. The title company finds a weird easement from 1920, they'll just list it as an exception, meaning if it ever becomes a problem, they won't help you. Your attorney will fight this. They will review that list of exceptions and argue with the title company to remove any that are invalid or no longer applicable. They work to get you the broadest, most comprehensive coverage possible. They ensure your safety net has as few holes as possible. A realtor doesn't have the legal standing or expertise to debate the nuances of policy exceptions with the title company's underwriter. So the title is clean, the ghosts have been exorcised from the property's past. You're safe, right? Not yet, because now we have to talk about the contract itself. The dense 50-page document filled with legalese, deadlines, and traps that can cost you your deposit, or even the entire house. This document is the battlefield, and every single sentence is a potential landmine. Your realtor, who is fantastic at their job, pulls out a contract. It's usually a standardized form, created by the local association of realtors. It's been used in thousands of deals. It looks safe, feels official. They'll confidently point to the blanks. Okay, we put the purchase price here. Your names go here, and we'll ask for a closing date here. They are an expert at filling in these blanks. They know the market, they know what's a standard amount for an earnest money deposit, and they know the typical timeline for inspections. They are playing the game according to the local customs, and that is an incredibly valuable skill. But here's the critical difference. A realtor's job is to use the pre-written rules to get the deal to the finish line. An attorney's job is to read those rules and ask, what if the game is rigged against you? The attorney's job is to rewrite the rules in your favor. Let's start with the big three escape hatches: the contingencies, inspection, financing, and appraisal. These are your get-out-of-jail-free cards if something goes wrong. A realtor will, of course, make sure these clauses are in the contract. But the devil isn't just in the existence of the clause. It's in the specific wording. Take the inspection contingency. The standard clause usually says you can cancel the contract if you find major structural defects. Sounds good, right? But what's the legal definition of major? Is a leaky roof a major defect? The seller might say, no, I can patch it for $200. So they send a guy up there with a bucket of tar, he slaps some on, and they claim it's repaired. You, the buyer, are still worried. You know that patch won't last a single winter. But because the defect has been remedied, the standard contract language might force you to either close on the house with a shoddy repair or forfeit your $10,000 deposit. An attorney sees this trap from a mile away. They'll strike out vague language like major defects and replace it with something like, the buyer, in their sole and absolute discretion, must be satisfied with the results of the home inspection. See the difference? It's no longer a debate about what's major. It's about whether you are satisfied. If you don't like the color of the wiring, you can walk. If you have a bad feeling about the foundation, you can walk. If the seller's repair is a joke, you can walk. With your deposit safely in your pocket, the attorney has turned a potential argument into your personal, non-debatable escape hatch. Now let's talk about financing. The standard clause says if you can't get a loan, you can cancel the contract. Simple. But what if the bank approves your loan, but at an interest rate that just shot up from 5% to 7% overnight? Your monthly payment is now $600 higher than you budgeted for. You technically can get the loan, but you can no longer afford the house. The standard contract language often doesn't protect you here. You'd have to either take the unaffordable loan or lose your deposit. An attorney anticipates this. They will add a custom clause, a rider, specifying that the financing contingency is not only dependent on securing a loan, but on securing it at an interest rate not to exceed a specific number, say 5.5%. If rates jump to 5.6%, you are free. They'll also add protections for other lender-related nightmares. What if the bank's appraiser comes in low? What if the lender suddenly changes their requirements a week before closing? What if you lose your job, something completely out of your control, and the bank pulls your financing? An attorney builds these real-world scenarios into the contract, ensuring your earnest money isn't sacrificed to a standard form's blind spots. And then there's the most misunderstood and dangerous phrase in all of real estate: as is. When a property is listed as is, many buyers and even some agents think it means you get what you get, and you don't get upset. They think it's a shield for the seller against any and all problems. This is a costly myth. A realtor might tell you, "Don't worry, we still have the inspection period." And they're right. But an attorney knows that the as-is clause is a psychological and legal weapon used by the seller. After the inspection, if you ask for a credit for a faulty furnace, the seller's agent will just point to the contract and say, "Sorry, you agreed to buy it as is." They're trying to shut down the negotiation before it even starts. An attorney defangs this clause immediately. They will add language that says, "Notwithstanding the as-is provision herein, this contract is fully contingent upon the buyer's satisfaction with a home inspection." This simple addition legally clarifies that your right to inspect, negotiate for repairs, or terminate the contract based on that inspection is more powerful than their as-is clause. It keeps you in the driver's seat. Furthermore, an attorney will tell you that as-is does not relieve the seller from their legal obligation to disclose any known hidden defects. If they knew the basement flooded every spring and didn't tell you, as-is won't protect them in a court of law. But here's where an attorney provides a level of protection that is completely outside the scope of a realtor's job. It's a concept called representations and warranties. A realtor's contract is about the transaction, the transfer of property for money. An attorney's contract is also about truth and accountability. Imagine you're buying a house with a beautiful brand new finished basement. The seller says their brother, who's handy, did the work. It looks great. You close on the house. A year later, you get a notice from the city. The work was never permitted. The electrical wiring isn't up to code, the plumbing is illegal, and you have to tear it all out at a cost of $30,000. Or worse, a fire starts because of that faulty wiring. With a standard realtor's contract, you have almost no recourse. The deal is done. But an attorney, during the contract phase, could have added a representation and warranty. This is a clause where the seller is forced to go on the legal record and state certain things as fact. For example, the seller represents and warrants that all work performed on the property was done with all necessary municipal permits and is in full compliance with all building codes. Now, if you discover that unpermitted basement a year later, you don't just have a problem, you have a breach of contract. You can sue the seller for the cost of the repairs, and you will win because they legally warranted it to be true. They lied on a legal document. This single clause can protect you from tens, even hundreds of thousands of dollars in post-closing nightmares. A realtor cannot add this. They are not licensed to draft custom legal language that creates this kind of long-term liability and protection. It is purely the domain of a lawyer. So when you look at that 50-page document, remember it's not a formality. It's the entire legal foundation of the biggest purchase of your life. A realtor expertly navigates the standard path. An attorney stress tests the path, paves over the potholes, and builds legal guardrails to keep you from falling off a cliff. The contract has been drafted, the custom protections are in place, and you've signed on the dotted line feeling secure. But the battle isn't over. In many states, the war has just begun. Because now, that contract you so carefully crafted gets sent to the other side, to the seller's attorney. And they have a very different agenda and a very, very red pen. This is the crucible of the deal. This 3 to 5 day period, known in many states as attorney review, is where your dream of homeownership can turn into a legal nightmare. The seller's attorney receives your pristine, buyer-friendly contract and sees it not as a fair offer, but as a list of liabilities for their client. Their job is to protect the seller, and protection means one thing: shifting as much risk as humanly possible from their side of the table to yours. That red pen isn't for correcting typos. It's a weapon. And the first target is almost always the inspection contingency. Your attorney fought to give you a wide-open window, say 10 business days, to bring in any expert you want, to scrutinize every inch of that property, and to walk away if you find anything that makes you uncomfortable. The seller's attorney sees this as a 10-day free option for you to cancel for any reason. So the red pen comes out. They'll slash that window from 10 days to 5. They'll add language that says you can only bring in a licensed home inspector and a pest inspector, and that's it. No structural engineer, no roofer, no electrician, unless the general inspector specifically calls for it in their written report. They are trying to limit what you're allowed to discover. Then they go a step further. They attack your right to negotiate. They'll insert a clause that says you can't ask for repairs or a credit for any issue that costs less than, say, $2,000 to fix. They're trying to disqualify all the small and medium-sized problems from the negotiation table before you even find them. And the deadliest change of all? They'll try to transform your right to cancel into a narrow, nearly impossible-to-use escape hatch. They'll change the wording so you can only terminate the contract if there are major structural or environmental defects. What defines major? They leave it deliberately vague. A leaky roof? Maybe not major. Faulty wiring? Arguable. A cracked foundation? Okay, maybe that qualifies. They are building a cage around you, and the bars are made of legal jargon. While your realtor is focused on the spirit of the deal, the price, the closing date, the excitement, your attorney is at war with the letter of the law. They see these changes and immediately understand the danger. They know that a 5-day inspection window in a busy season is a logistical impossibility. They know that the major defect language is a trap designed to force you to buy a house with serious, expensive problems. Next, the seller's attorney takes aim at your financing. Your mortgage contingency is your shield. Says if you can't get a loan, you get your deposit back. The seller's attorney sees this as your personal get-out-of-jail-free card. They want you locked in. So they'll shorten the time you have to secure a mortgage commitment from 30 days down to 21. They'll add a clause that says if your bank denies the loan because of something you did, like quitting your job or buying a new car, you forfeit your deposit. They'll demand to see your pre-approval letter, your proof of funds, and sometimes even a letter from your loan officer stating your application is already in process. They are putting you on a clock and under a microscope. And then comes the clause that every buyer's attorney dreads. Time is of the essence. It sounds innocent, like a motivational poster. In a real estate contract, it's a guillotine. Without this clause, if you're a day or two late for the closing, it's usually not a catastrophe. You work it out. But when a seller's attorney adds time is of the essence, that closing date becomes a sacred, unbreakable deadline. If your bank has a last-minute paperwork delay, if the wire transfer is slow, if you get stuck in traffic and you are not at that closing table pen in hand on the specified date and time, you are in breach of contract. The seller can cancel the deal and, in most cases, keep your entire 5 or 10% deposit. It's the legal equivalent of a tripwire. And their attorney just set it right in your path. This is where the fundamental difference between your realtor and your attorney becomes crystal clear. Your realtor is on the phone with the other agent trying to keep the peace. They're saying things like, "Come on, my buyers are strong, they're not going to walk away over a few days for the inspection." The seller is just being cautious. They are the diplomat, the relationship manager. Their primary goal is to get everyone to agree so the deal can move forward. They are trying to find the yes. Your attorney's job is to protect you from the what if. They aren't concerned with hurt feelings. They send a formal letter back to the seller's attorney. It's a counteroffensive. They reject the time is of the essence clause entirely. They change major structural defects back to the much broader, any condition unsatisfactory to the buyer. They extend the inspection window back to a reasonable 10 days. They are fighting for your rights, for your money, for your ability to walk away from a bad deal without losing everything. This can go back and forth 2, 3, even 4 times. Each letter is a volley in a high-stakes tennis match. The seller's attorney adds a clause saying the appliances are being sold as is, with no guarantee they'll even be working on closing day. Your attorney fires back, demanding that all systems and appliances be in good working order at closing. The seller's attorney tries to limit the seller's liability for any misstatements they made about the property. Your attorney strengthens the clause, making the seller swear that everything they've disclosed is true to the best of their knowledge. During this intense, multi-day battle, your realtor is your source of on-the-ground intelligence. They're talking to the other agent, trying to figure out what the seller really cares about. Is it the closing date? Are they worried about a low appraisal? This information is gold. The realtor relays it to your attorney, who can then use it to strategize. Maybe you concede a slightly shorter inspection period in exchange for them removing that terrifying time is of the essence clause. This is the synergy of a great team. The realtor provides the market context and emotional intelligence, while the attorney provides the legal firepower and contractual protection. Finally, after a nerve-wracking flurry of emails and phone calls between the lawyers, a compromise is reached. The final version of the contract, scarred with track changes and amendments, is agreed upon by both sides. The attorneys declare the review period over. You are now officially under contract. This is a huge milestone. The legal framework is locked in. The price is set. The terms are fixed. For a moment, you can breathe a sigh of relief. You've survived the paper war. But the real war is just beginning. Because all of this negotiation, all of this legal combat, has been about a theoretical house. It's been about words on a page. Now it's time to confront the reality. It's time to find out what secrets those walls are hiding. The contract you just fought so hard for gives you the right to inspect. And now the inspector, the man with the flashlight and the clipboard, the detective you've hired to uncover every flaw, every leak, every crack, is about to walk up to the front door. And what he finds in the next few hours could make that brutal attorney review feel like child's play. The inspector's truck is parked out front. It's not flashy. It's a working vehicle, filled with ladders, tools, and devices that look like they belong in a sci-fi movie. This person isn't here to sell you anything. They're not here to make friends. They have one job: to find what's wrong. They work for you and you alone. Your realtor made the recommendation, pulling from a short list of trusted, notoriously thorough, almost painfully meticulous inspectors they've worked with for years. They know a soft inspector who glosses over problems to keep a deal alive is the most expensive mistake a buyer can make. Your realtor scheduled this, coordinated with the seller's agent, and is now standing on the porch with you, giving you a quiet nod as the inspector approaches. For the next 3 to 4 hours, this house, your potential future home, will be treated like a crime scene. Every system will be interrogated. The inspector descends into the crawl space, a place most homeowners never see, searching for moisture, pests, and structural decay. They're on the roof, walking the shingles, checking the flashing around the chimney. They're in the attic, measuring insulation depth and looking for signs of roof leaks from above. They're running every faucet, flushing every toilet, testing every outlet. They're scrutinizing the electrical panel, a metal box of mysteries, looking for double-tap breakers or outdated wiring that could be a fire hazard. They're examining the HVAC system, the water heater, the very lungs and heart of the home, noting their age, their condition, their life expectancy. This is where the realtor's role shifts from matchmaker to project manager and emotional ballast. They are there with you, walking through the house, but more importantly, they're managing the experience. When the inspector points to a dark stain on the ceiling and says, "That's evidence of a past leak," your heart sinks. You see a $1,000 repair bill. You see mold. You see disaster. The realtor, having seen this 100 times, steps in. "Okay, let's look closer. Is the area damp now?" "No." The seller disclosed they had the roof flashing repaired last year. "This is likely old. We'll note it, but it's probably a non-issue." They're not dismissing your concern. They're contextualizing it. They're the translator between the inspector's clinical, often alarming, observations and the reality of homeownership. No house is perfect, not even new construction. A good realtor has prepared you for this, reminding you that the goal isn't to find a flawless property, but to understand exactly what you are buying: the good, the bad, and the ugly. Then the inspector emerges from the basement. He has a serious look on his face. He points to a hairline crack in the foundation wall, barely visible. Next to it, he points out some fine sawdust-like debris along a floor joist. He pulls out a photo on his tablet. "This is a termite tunnel," he says, "and that crack needs to be monitored." In your mind, the deal is dead. The house has termites and a broken foundation. It's a money pit. You're ready to walk away. This is the moment your realtor earns their commission. They pull you aside. "Okay, deep breath. Let's not panic. The report will say evidence of wood-destroying insects. It doesn't necessarily mean there's a current, active infestation." And he called that a settlement crack, which is common. The key is what we do next. The realtor's job is to strategize. They immediately suggest a plan. We need to exercise our rights under the inspection contingency. First, we'll get a licensed pest control company out here tomorrow to do a full termite inspection and give us a quote for treatment and a repair bond. Second, we'll hire a structural engineer to evaluate that crack and give us a written report on its severity. It might cost us $500 for these follow-ups, but it's the best money you'll ever spend. You see, the realtor is the field general. They are assessing the situation on the ground and formulating a business plan. They understand the market, they know what sellers are likely to agree to, and they know how to frame the request. After getting the reports back, let's say the news is mixed. There's no active termite infestation, but there was a past one, and the recommendation is a preventative treatment and a 1-year warranty, costing $1,200. The structural engineer says the crack is non-structural, a result of normal settling, but recommends epoxy injection and sealing to prevent moisture intrusion, a job quoted at $1,800. So, you have $3,000 in unexpected but necessary repairs. Your realtor sits down with you. "We have a few options," they explain. 1. We can ask the seller to perform these specific repairs before closing using licensed contractors. 2. We can ask for a price reduction of $3,000. Or 3. My recommendation, we ask for a $4,000 credit at closing. This covers the costs and gives you a little extra for the hassle, and more importantly, it lets you control the quality of the repair. You hire the contractors, you oversee the work after you own the home. It's the cleanest way to do it. You agree. The strategy is set. Now the realtor tags in the attorney. The attorney's phone rings. The realtor briefs them on the findings and the agreed-upon strategy. The attorney's role is not to second-guess the business decision. They're not going to say, "You should have asked for $5,000 instead of $4,000. Their job is to take that business strategy and transform it into an inescapable legal instrument. They are the sniper, taking the general's plan and executing it with lethal precision. While the realtor was managing your emotions and forming a plan, the attorney was thinking about the contract. They review the inspection contingency clause they fought for during the initial review. It says you have 10 days to perform inspections and make a request. Today is day 8. The clock is ticking. The clause says you can request repairs or cancel the contract if the issues are major. The attorney needs to frame this request perfectly. If it's too aggressive, the seller might just say no and call your bluff. If it's too weak, you might not get what you need. The attorney drafts a formal letter or addendum, addressed to the seller's attorney. It doesn't say, "Hey, we found some stuff and we're a little worried." It says, with the cold, hard clarity of a legal document, "Pursuant to paragraph 12 of the purchase and sale agreement, the buyer hereby notifies the seller of the following objectionable conditions discovered during the home inspection, as detailed in the attached reports from pest control company name and structural engineering firm name. Buyer requests a closing cost credit in the amount of $4,000 from the seller in lieu of repairs. This request is a condition of proceeding with the purchase. A response is required within 48 hours, by 5 p.m. on date. Should seller not agree to the aforementioned credit, buyer reserves all rights under the contract, including the right to terminate this agreement and demand the immediate return of all earnest money deposits." Do you see the difference? The realtor handled the what. The attorney handled the how. The realtor's work was about negotiation, psychology, and market knowledge. The attorney's work is about contractual obligation, risk mitigation, and legal enforcement. They've taken your request and put the full weight of the law behind it. They've created a clear binary choice for the seller. Agree to the credit, or the entire deal is at risk, and you will get your deposit back. There is no ambiguity. There is no room for misinterpretation. And what if the seller agrees to make the repairs instead? The attorney's job gets even more complex. They draft an addendum specifying the exact work to be done, that it must be completed by a licensed and insured contractor, that all receipts and warranties must be provided to the buyer prior to closing, and that the buyer reserves the right to a final walkthrough to approve the repairs. They are closing every loophole, ensuring the seller can't just have their brother-in-law slap some caulk on the crack and call it a day. The realtor is your advocate in the marketplace. The attorney is your champion in the legal arena. During the inspection, they work in perfect tandem, one diagnosing the physical health of the house and its financial implications, the other ensuring the contractual cure is legally sound and enforceable. Now the addendum has been sent. A digital missile launched from your attorney's office to the sellers. Everyone holds their breath. Your dream home hangs in the balance, resting on this single document. For the next 48 hours, there's nothing to do but wait for the response. But the response that comes back isn't what anyone expected. It's not a yes. It's not a counteroffer. It's a single defiant sentence that threatens to blow the entire deal apart and pit your team against theirs in a final high-stakes showdown. The email from the seller's attorney sits on your screen. A digital grenade with the pin pulled. It reads, "Be advised, the purported easement for driveway access is defective and considered abandoned by my client. Access will not be granted post-closing." Abandoned. Defective. Your heart sinks. The driveway, the one you pictured your kids learning to ride a bike on, the one that leads to the two-car garage you've dreamed of for years, is not yours to use. The house is effectively landlocked, its value instantly slashed. Your realtor, Sarah, calls you, her usually confident voice tight with uncertainty. I don't understand. It was right there in the title search. I've sold 100 homes, and I've never seen a seller just deny a recorded easement. My broker is saying the same thing. This isn't a negotiation tactic anymore. This is a legal threat, and I am not qualified to advise you here. You have to talk to your attorney. Now. She's right. This is no longer about paint colors or closing costs. This is about fundamental property rights. A battle fought not with offers and counteroffers, but with case law and legal precedent. This is the moment the spotlight swings from the realtor to the real estate attorney, and the entire nature of the game changes. You forward the email to David, your attorney. There's no frantic phone call. No panicked reply. A few hours later, a calm, measured response appears in your inbox. Received. I will review the title history and the relevant statutes. Please do not communicate further with the seller or their agent. I will handle this. And with that, David descends into the depths of the county's property records, a legal archaeologist digging through decades of digital and paper history. This is a world far beyond the MLS listings and market comps that a realtor masters. This is where the deal's true foundation is tested. First, David isn't just looking at your title report. He's pulling the source documents. He finds the original deed from 1962, the one that first subdivided the land and created the easement. He's not just reading it, he's dissecting it. He's analyzing the specific archaic language. Was the easement created in gross, meaning it was granted to a specific person? Or was it appurtenant, meaning it was attached to the land itself, passed down from owner to owner forever? The seller's entire argument hinges on this distinction. David confirms the language is ironclad. It's an easement appurtenant. It runs with the land. Strike one against the seller. But he doesn't stop there. The seller's attorney used the word abandoned. In property law, that's a powerful and specific claim. To prove abandonment, they would need to show a long period of non-use plus a clear, affirmative action by a previous owner to relinquish the right. So David goes on the hunt. He pulls every single deed for both your potential property and the seller's property for the last 60 years. He's building a timeline, a family tree of ownership. He's looking for any document, any affidavit, any recorded notice where a past owner of your house might have signed away their right to the driveway. He scours the records for years, cross-referencing tax maps and permit filings. He finds nothing. No document, no hint of a surrender. The driveway has been in continuous use since the Kennedy administration. Strike two against the seller. Now David enters the final, most crucial phase of his work, the part that no one else on your team can do. He logs into a professional legal research database, a powerful search engine of the law itself. He's not just looking for statutes, he's looking for case law. He's searching for every time a court in your state has ruled on a disputed easement. He's looking for precedent. He types in keywords: easement by grant, abandonment, hostile termination of access. He reads through dozens of judicial opinions, some recent, some dating back a century. He's looking for a case with a similar fact pattern. And then he finds it. Miller v. Thompson, a state appellate court decision from 1988. In that case, a property owner tried to do the exact same thing. Unilaterally declare a perfectly valid, recorded easement to be defective because they no longer wanted to share their driveway. The judges in Miller v. Thompson were not amused. Their written opinion was a scathing rebuke, stating that a recorded property right cannot simply be wished away. They established a clear three-part test for challenging such an easement, a test the seller in your deal could not possibly meet. This case is the legal equivalent of a royal flush. It's the definitive answer. Strike 3. The next morning, David doesn't call the other attorney to argue or negotiate. He doesn't send a snippy email. He orchestrates a formal, overwhelming show of legal force. He drafts a 12-page letter, a document as precise and devastating as a guided missile. The first section calmly lays out the undisputed history, citing the exact book and page number of the 1962 deed in the county records. The second section methodically dismantles the claim of abandonment, citing state law and the complete absence of any supporting evidence in the 60-year chain of title. The third and most powerful section is a masterclass in legal argumentation. He cites Miller v. Thompson, quoting the most damning paragraphs from the 1988 court decision directly in his letter. He essentially shows the other attorney that not only are they wrong, but a court in their own state has already said so in no uncertain terms. He concludes the letter with a paragraph that leaves no room for debate. It's a tactical shift from defense to offense. Therefore, he writes, your client's position is without legal merit. We consider the easement to be valid, recorded, and non-negotiable. We have instructed our client to proceed with all preparations for closing on the contractually mandated date. Please be advised that any action taken by your client to obstruct the use of this easement, either before or after closing, will be met with immediate legal action seeking a temporary restraining order, a permanent injunction, and financial damages, including all associated attorney's fees and court costs, as provided for under state law. He attaches copies of everything: the original 1962 deed, the key pages from the Miller v. Thompson decision, and a satellite image of the property with the easement clearly outlined. He sends it via certified mail and email. The chessboard has been completely flipped. This is no longer a real estate negotiation. Sarah, your realtor, brought you the opportunity and negotiated the price. But David, your attorney, just defended your fundamental right to own it. The seller and their attorney weren't expecting a polite discussion. They were expecting to bully a buyer into walking away, or paying a hefty sum for a right they already owned. Instead, they got a history lesson, a legal brief, and an unambiguous threat of a lawsuit they would almost certainly lose. The response from their side is silence. A full 24 hours pass. The air is thick with tension. Your realtor calls, anxious. Anything? Have they responded? Nothing. Another day crawls by. The closing is now less than a week away. Your lender is calling for final confirmation. The movers are booked. Every passing hour feels like an eternity. You refresh your email over and over, waiting for the verdict. Finally, an email notification chimes. It's from your attorney, David. The subject line contains just 3 words, and those 3 words will determine whether you get the keys to your dream home or the bill for a lawsuit you never wanted. You're holding your breath, staring at the screen. Your finger hovers over the mouse, a millimeter away from the click that will either bring immense relief or crippling disappointment. The subject line: summary judgment granted. You don't know exactly what that means, but granted sounds good. You click open the email. Short, professional, and to the point. David explains that he filed a motion for summary judgment, arguing to the court that based on the undisputed facts of the case, the signed contract, the seller's clear breach, there was no need for a full trial. The law was entirely on your side. The judge agreed. The court has ordered the seller to return your entire earnest money deposit immediately. Not only that, but the judge also ruled that the seller is responsible for paying your legal fees. You read that sentence again, and a third time. You're not just getting your money back. You're being made whole. You won. Decisively. A wave of relief washes over you so powerful it almost makes you dizzy. The months of stress, the sleepless nights, the endless what-ifs, they evaporate in an instant. You didn't just dodge a bullet, you caught it and you're sending it right back. You immediately think of Sarah, your realtor. You should probably let her know. But what would she have done in this situation? She was fantastic at finding the house, at negotiating the inspection items, at keeping the energy positive. But when the seller dug in their heels and the legal threats started flying, her role fundamentally changed. She could offer sympathy. She could say, "I'm so sorry you're going through this." She could even give you the names of a few attorneys. But she couldn't step into the arena for you. Her license, her entire profession, is built around bringing parties together to make a deal happen. It is not built for tearing an opponent's legal arguments apart in front of a judge. That's where David, the attorney, lived. His world wasn't about staging or curb appeal. It was about statutes, precedents, and procedural motions. He didn't just advise you. He represented you. He became your champion in a system you didn't understand, wielding rules and laws as his weapons. Sarah helped you find the dream. David protected you from the nightmare. And that, you realize, is a difference worth every single penny of his retainer. With the lawsuit behind you and your deposit safely back in your bank account, you're free. The ordeal was painful, but it taught you an invaluable lesson. You're wiser now, more cautious. You decide to start looking again, this time with both Sarah and David on your team from day one. A few weeks later it happens. You find another house. And honestly, it's even better than the first one. It's on a quieter street, has a bigger backyard, and features a stunning, recently renovated detached cottage. You imagine it as the perfect in-law suite for your aging parents, or maybe even a home office completely separate from the main house. It's a game changer. Sarah is ecstatic. "This is the one," she says. "I can feel it. Everything happens for a reason." This time the process is smooth as glass. The sellers are a lovely older couple looking to downsize. The inspection report comes back practically glowing. There are no bidding wars. It feels like the universe is finally giving you a break. You go under contract, and as a matter of course you forward all the documents to your attorney David for his review. While Sarah is coordinating appraisal and final walkthroughs, David is doing something else. He's in the weeds. He's pulling public records, reviewing the title report line by line, and cross-referencing everything with local municipal and zoning codes. It's work that happens completely in the background, invisible to most homebuyers. A week before closing you get a call. It's David. His tone isn't alarming, but it's serious. "We need to talk about the cottage," he says. He explains that while digging through the city's permit records, he found something troubling. Or rather, he found a lack of something. The main house has a thick file of permits for every update over the last 50 years. But the cottage in the back? Nothing. No building permit. No electrical permit. No plumbing permit. According to the city, that beautiful, fully finished in-law suite doesn't legally exist as a dwelling. Your heart sinks. What does that mean? You ask. This is where the path splits, where the difference between your realtor and your attorney becomes profoundly clear. You call Sarah to tell her the news. Her immediate reaction is to find a way to save the deal. That's her job. "Okay, don't panic," she says, her voice reassuring. "This happens sometimes. We can handle this. We'll go back to the sellers and ask for a credit. We'll figure out what it might cost to permit it, or we'll just get a big chunk of money off the price to make up for it. We can make them pay for this. We can still make this work." Her solution is transactional. It's about money. It's about adjusting the numbers to get everyone to the closing table so she can collect her commission and you can get your house. She sees a problem that needs a financial solution. Then you talk to David again. He sees something entirely different. He doesn't see a financial problem. He sees a legal and liability time bomb. He lays it out for you not as a deal saver but as your risk advisor. "Let's forget about the seller for a moment and talk about you," he begins. "If you buy this property, you inherit this problem. The city could discover the unpermitted structure at any time. They could hit you with daily fines until it's rectified. Best case, they force you to go through a costly and uncertain process to try and legalize it. Worst case, they issue a demolition order, and you have to pay to tear down one of the biggest assets of the property you just bought." He continues, "Now let's talk about insurance. You mentioned putting your parents in there. What if there's a fire? What if someone slips and falls? When your insurance company discovers the unit was never permitted or inspected for safety, They will almost certainly deny your claim. You would be personally on the hook for medical bills, damages, everything. The financial exposure is potentially catastrophic. And finally, he addresses the future. Even if you get away with it, what happens in 10 years when you want to sell? You'll be in the exact same position as the current seller, forced to either disclose a major legal issue that will tank your property value, or roll the dice and hope your buyer isn't as diligent as we are. Sarah was trying to solve today's problem. How to close the deal. David was protecting you from tomorrow's, next year's, and next decade's problems. He wasn't thinking about the commission. He was thinking about your financial future, your legal liability, and your peace of mind. He then presents you with your options, not as suggestions, but as clear legal pathways with distinct consequences. 1. You can terminate the contract. Based on the seller's failure to disclose a known material defect, you can likely walk away right now and get your full deposit back. It's the cleanest and safest option. 2. You can demand the sellers legalize the structure before closing. This would be the ideal outcome, but he warns you it's almost certainly a fantasy. The process could take months, even years, with no guarantee of success, and the sellers would never agree to that open-ended liability. 3. You can proceed with the purchase, but with full knowledge and a strategy to mitigate the risk. This, he explains, is more than just getting a simple credit. He would need to draft complex indemnity clauses into the contract. He would calculate a price reduction based not on a contractor's guess, but on a true risk assessment, factoring in potential demolition costs, fines, legal fees, and the permanent diminution of the property's value. He would be creating a legal shield for you. Suddenly, the choice isn't about backsplash and paint colors anymore. It's a sophisticated business decision. The perfect house is now a complicated legal and financial puzzle. Sarah, your realtor, brought you to the door. David, your attorney, is forcing you to look at the faulty foundation it's built on. And now you have to decide whether to walk away or to pick up a shovel. That choice, to walk away or pick up a shovel, isn't made in a vacuum. It's made in a storm of conflicting advice. Sarah, your realtor, calls you that evening. Her voice is a cocktail of optimism and urgency. She's already been on the phone with the seller's agent. Look, she says, it's not a deal breaker. It's a small utility easement. Most properties have them. The seller's agent said they've never even seen the utility company use it in the 20 years they've lived there. We can ask for a credit, maybe $5,000 for the inconvenience, and keep this thing moving. I don't want you to lose this house over a technicality. You can hear the conviction in her voice. She genuinely believes this. To her, this easement is a hurdle, not a wall. It's a problem to be solved to get to the finish line, the closing table. Her entire focus, her training, her financial incentive, is geared towards closing the deal. Problem is just a negotiation point. A risk is something to be mitigated with a small price reduction. She's the ultimate deal maker. Her job is to build a bridge over any obstacle, no matter how shaky, to get you to the other side where you sign the papers and she gets her commission. She's not being malicious. She's doing her job as she sees it. She's selling you the dream, and she doesn't want a legal document to wake you up. Then you talk to David, your attorney. There is no urgency in his voice. There is only clarity. He says, let's set aside the seller's anecdotal experience. What they've seen for 20 years is legally irrelevant. What is relevant is the document recorded with the county. That document gives the utility company the permanent, legal right to bring heavy machinery onto your property, dig a 10-foot trench through your backyard, and disrupt your life, at any time of their choosing, without your permission. They might not do it for 50 years. They might do it next Tuesday. A $5,000 credit will not change that legal reality. He continues, his tone even and measured. More importantly, this easement wasn't properly disclosed. This gives us leverage. But before we talk about leverage, we need to talk about your future. When you go to sell this house in 10 years, you will be legally required to disclose this. And your potential buyer might have an attorney like me who explains the full ramifications to them. This easement permanently impacts the value and desirability of this property. It's not a technicality. It's a fundamental defect in the asset you're about to purchase. This is the critical divergence. Sarah sees a problem with the deal. David sees a problem with the asset. The realtor is focused on the transaction. The attorney is focused on the property itself, the tangible and intangible rights you are acquiring for the next 30 years. David's incentive isn't a commission check that vanishes after closing. His incentive is his professional duty, his reputation, and the flat fee you're paying him to protect you from exactly this kind of long-term hidden risk. He has no financial stake in whether you buy the house or not. This independence is his superpower. He is not a deal maker. He is your risk manager. And if the risk is too great, his job is to be the deal breaker. You arrange a conference call. You, Sarah, and David. It's a masterclass in two different worldviews colliding. Sarah starts outlining her plan. I think we have a strong case to ask for a $10,000 price reduction. That's more than fair. It compensates them for the issue, and it keeps the deal on track for our original closing date. David waits for her to finish, then he speaks. A $10,000 reduction doesn't solve the core issue. It's a bandage on a broken bone. The property was marketed as having a large, private backyard suitable for a pool, which was one of my client's key requirements. This easement makes installing a pool impossible and renders the yard not so private. This isn't a simple matter of compensation. It's a material misrepresentation of the property. Sarah pushes back, a slight edge to her voice. But David, no deal is perfect. We can get the sellers to sign an affidavit saying they've never had issues. We can make sure the title insurance is solid. David cuts in, politely but firmly. The seller's affidavit is worthless the day after a backhoe shows up in the yard. And a standard title insurance policy will list this recorded easement as an exception, meaning they won't cover you for it because it's a known, documented issue. My concern isn't about making this deal work. It's about whether this is the right deal for my client, period. And there it is. The chasm between the two roles laid bare. Sarah is trying to salvage the sale. David is trying to protect the buyer. It's not that one is good and one is bad. It's that they have fundamentally different functions. A realtor's job is to bring people together and facilitate a transaction. They are a salesperson, a marketer, a negotiator for price and terms. An attorney's job is to represent your legal and financial interests exclusively, with a duty that transcends the deal itself. This is called fiduciary duty. Fiduciary duty is one of the most important concepts in law, and it's what you're paying an attorney for. It means that they must act in your best interest, with undivided loyalty, even if it means blowing up a deal and costing themselves work. They are legally bound to prioritize your well-being above all else, above the sellers, above the realtors, and even above their own. A realtor has duties to their client, of course, but the attorney's fiduciary responsibility is a legal shield, forged in centuries of law, designed to be absolute. Guided by David, you make a decision. You're not picking up a shovel to fix the foundation. You're using the faulty foundation as a wrecking ball. David drafts a letter to the seller's attorney. It's not a request. It's a notification. It states that the property was materially misrepresented, that the failure to disclose the nature of the easement constitutes a breach, and that his client is reserving all rights to terminate the contract and demand the return of their deposit. The letter doesn't even mention a price reduction. It's a power move. The seller's world is turned upside down. They know that if you walk away, they are now legally on the hook to disclose this easement to every single future potential buyer. The perfect backyard section of their listing is now a lie. Their property is suddenly much harder to sell. Their realtor can't just gloss over it anymore. 2 days later, the call comes. Not from Sarah, but from David. They've responded, he says. They are offering a $75,000 reduction in the sales price. $75,000. Not 5, not 10. An amount that actually reflects the permanent, long-term devaluation of the property. An amount Sarah would have never dreamed of asking for, because her goal was to smooth things over, not to go to war. David's goal was to enforce your legal rights, and in doing so, he completely redefined the financial reality of the deal. You take the deal. You buy the house. You give up the dream of a pool, but you do so with a $75,000 cushion. You sign the papers, not with the blind excitement of a new homeowner, but with the calculated confidence of a protected investor. You didn't just buy a house, you executed a strategy. And that shift in mindset is everything. Because the final signature on the deed isn't the end of the story. It's the beginning of your new reality. And there's one last, critical role each of these professionals plays after the keys are in your hand. This post-closing period is where the true nature of their roles becomes crystal clear. It's the epilogue to your home buying story, and it sets the stage for your entire life in that home. Let's start with the realtor. A good realtor doesn't just vanish after the commission check clears. In fact, for the best in the business, the closing is just a transition point in your relationship. They shift from being your transaction guide to becoming your long-term home resource. Think about it. The first few weeks in a new home are chaos. You don't know who the best plumber is. You have no idea which internet provider has the best service on your specific street. You need a recommendation for a reliable painter or a landscaper who won't scalp your lawn. Who has that deep local knowledge? Your Realtor. They are a living, breathing directory of trusted local professionals. Their phone call can save you from weeks of trial and error and the agony of hiring the wrong person for a critical job. They are your bridge into the community. Beyond that immediate, practical help, a great realtor keeps a finger on the pulse of your investment. They'll send you market updates, letting you know how property values in your neighborhood are trending. They can tell you when it might be a good time to consider refinancing based on rising equity. They become your long-term strategic partner for what is likely the largest asset you own. And of course, there's a reason for this. They hope that when you're ready to sell in 7 or 10 years, or when your cousin decides to move to town, their name is the first one that comes to mind. It's a symbiotic relationship. They provide continuous value to you, and in return they build a reputation and a business built on trust, not just transactions. They're playing the long game, and you are the direct beneficiary. Now let's look at the attorney. Their post-closing role is less personal, but arguably even more fundamental. It's silent, invisible work that protects the very foundation of your ownership. While you're unpacking boxes, your attorney is ensuring the final critical legal mechanics are completed flawlessly. Their most important task is seeing to the proper recording of the deed. This is huge. The signed deed you get at closing is just a piece of paper until it is officially filed and recorded with the county clerk or registrar of deeds. This act is what makes your ownership part of the public record. It is the official legally binding announcement to the entire world that this property is now yours. An error in this process, a misspelled name and incorrect legal description, can create a cloud on title, a legal headache that can take months or even years to fix. The attorney is the final guardian of that process, ensuring your flag is planted on legally unshakable ground. Simultaneously, their office is handling the final disbursement of funds. That massive wire transfer you made doesn't just go into one big pot. It's a complex flow of money. The attorney's trust account or the title company they work with is like a financial control tower. They ensure the seller's old mortgage is paid off to the penny, that the seller gets their net proceeds, that both real estate agents receive their commissions, that any property taxes are paid, and that all other third parties like inspectors or surveyors are compensated. It's a high-stakes ballet of debits and credits, and their oversight ensures that no outstanding financial claims from the previous owner can come back to haunt you. But their most profound post-closing value is as your ultimate safety net. Let's imagine a nightmare scenario. A year after you move in, you get a letter from a construction company claiming the previous owner never paid them for the new roof they installed, and they're placing a mechanic's lien on your property. Or an unknown heir of the person who owned the house 2 owners ago suddenly appears, claiming they have a rightful stake in the property. These are not Hollywood fictions. They are rare, but devastating title defects. This is where your attorney's work becomes your shield. The title insurance policy they insisted on, the thorough title search they analyzed, and the meticulously prepared legal documents they drafted are what stand between you and a legal and financial catastrophe. You may never need this protection. You may live in that house for 50 years and never think twice about it. But the attorney's job is to prepare for the storm you never see coming. They built the legal fortress around your home, and their post-closing diligence is what makes sure the gates are locked and the walls will hold forever. So after this entire journey, what's the final verdict? Attorney versus realtor? You see now that it was never a competition. It's a partnership. It's a question of specialization. The realtor is your market expert. They are the strategist, the negotiator, the guide through the emotional and financial maze of finding and securing the right home. They operate in the world of people, prices, and potential. Their focus is on getting you the best possible deal in the present moment. The attorney is your legal expert. They are the protector, the validator, the architect of the legal framework that makes your ownership legitimate and permanent. They operate in the world of statutes, precedents, and risk. Their focus is on protecting you from the past and securing your rights for the future. To use one final analogy, the realtor is the brilliant ship's captain who navigates the treacherous, open seas of the market. They know the currents, they read the weather, and they chart the course to get you to your desired island. The attorney is the master shipbuilder and the harbor master. They ensure the vessel itself is structurally sound, legally registered, and free of any hidden defects before it ever leaves the port. And once you arrive, they are the ones who officially file the claim, ensuring that island is recognized as yours on every map in the world forever. You cannot have a successful voyage without both. One finds the destination, the other secures the claim. In some states, the law requires you to have both. In others, you have a choice. But the choice is not about saving a few dollars. It's about understanding the different kinds of risk you face in a real estate transaction. There's the risk of paying too much or buying the wrong house. That's the realtor's domain. And then there's the risk of buying a house with a fatal legal flaw. That's the attorney's domain. The ultimate goal of this deep dive was to empower you, to strip away the confusion and replace it with clarity. Because buying a home is the most significant financial and emotional decision most of us will ever make. It's more than a transaction. It's the process of turning a structure of wood and nails into the backdrop of your life. It's planting a flag in the ground and declaring, "This is my space. This is my home." Your realtor is the expert who helps you find the perfect piece of ground to plant that flag. Your attorney is the expert who makes damn sure that no one can ever legally force you to take it down. Building the right team is the first and most important step in that journey. Now you know how.